SJC-11699, Commonwealth versus Kimbroughtillery.
So, by the way, is that how it's pronounced?
Yes.
Kimbroughtillery?
Yes.
That's what I thought.
It helps to imagine
Excellent
a
job,
hyphen
Ms.
between the
Loon,
H
to
and the
get
T.
Kimbroughtillery correct. And there's no hyphen between Kimbrough and Tillery? It's just one name?
Right.
Okay, now that we've got that resolved, we can focus on the case. Please proceed.
Good morning. May it please the court. Rebecca Kiley on behalf of Kimbroughtillery. The parties agree that the petitioner is entitled to stop the Commonwealth from going forward on a second probation revocation proceeding, alleging that he has committed a new criminal offense, where at a prior probation revocation proceeding, a judge has already, after a hearing, determined that he did not commit that offense. And we ask this court to so hold.
Can I ask you some questions about that, though? Let's assume that there has been a determination that, well, I don't know, I guess it's a what level of determination is it? Preponderance of the evidence? I mean, what? Okay.
Yes, that's the standard that applies.
So a couple of weeks later, there's another probation revocation, and the Commonwealth proposes to offer more evidence. Because now maybe the defendant has actually confided in a friend, and now that's brought to the Commonwealth's attention. I mean, I'm just wondering, is it because it's the same evidence?
No,
I mean, certainly it can go to trial. I mean, you're not saying
Yes.
that this somehow trumps a trial.
No, I think it's clear under Crockett versus Commonwealth that this can go to trial.
And after a trial, if there's a conviction, I take it there could be a probation revocation based on the same offense?
You know, where a defendant has already been found not to have violated his probation by committing that new offense, I'm not sure what the answer to that would be.
How is this? This is not a trial. This probation revocation is not a trial.
Yes.
Now there has been a trial. All the evidence has been presented. There's guilt beyond a reasonable doubt. Why couldn't that be used in a subsequent probation revocation hearing? Because some judge, after hearing from a couple of evidence, said, I don't think there's enough evidence. I mean, he wasn't found not guilty by the judge.
Sure. I mean, that's
I don't think
not
there's enough
the
evidence
situation.
at this point in time to do this, right? Isn't that really essentially the finding?
On the facts of this case, I would disagree. This, I think, was a pretty unusually full hearing for a district court probation revocation proceeding at which 5 witnesses testified. There's no suggestion by either party that there are any other witnesses who might have something valuable to offer who did not testify. I believe 3 of the witnesses were cross-examined.
But the principle is one that, so you're saying when there's a full evidentiary hearing with all the witnesses testifying, then there is sort of...
Wouldn't it, in that case, though, if I'm remembering correctly, the fact, yes, it binds with respect to the probation, as I thought the Commonwealth commendably agrees. It's the same burden of proof in all 3 of these probation revocation. If he went to trial, it's a different burden of proof. I mean, you don't have to get there, but it really does present a different. You're back into the land of different burdens of proof, and that may completely change the dynamic, as Crockett.
Yes, I mean, I think it's clear that if the trial precedes the probation revocation hearing and the defendant is convicted, that he can't seek to litigate the issue at a surrender hearing. It's funny, Justice Cordy, that you asked that question because I hadn't considered it until I was sitting here this morning about what happens if you win the probation revocation, are convicted at trial, and then the Commonwealth seeks again to revoke your probation. And frankly, I haven't heard of the Commonwealth seeking to do that under those circumstances. Perhaps they could, but it's not the question presented by this case.
But even under your theory, it's over. I mean, collateral estoppel means the probation had their chance, they lost, and the fact that new evidence would emerge would have no consequence.
Yes, I think that's what the analysis compels if this court adopts the
It really
the
compels that? It
analysis.
compels the result I have just said, which is after a conviction, there still could not be a revocation?
I'm sorry, it compels it on the facts of this case, where there has been no conviction, and in fact, the charge has been filed without a change of plea.
Okay.
But if
I'm worried about the limits of what this all means. It seems to me it's limited to a point in time and a range of evidence, no?
Yes, but I think the problem with what you're suggesting about, more evidence may emerge as they conduct further investigation is, I think that really gets at the unfairness that the defendant would face here if he were forced over and over again to litigate.
Okay, so he's been charged.
Yes.
And probation immediately, based on the charges, moves to revoke.
Yes.
There's a hearing, evidence is taken, the judge says no. Okay, no, I don't see there's enough evidence that he committed this crime. So the case proceeds in the ordinary course on the criminal docket, and before trial, the Commonwealth turns a couple of witnesses, gives them immunity, now has a case that they can prove beyond a reasonable doubt. Is this never to be revisited? Because at an early point in time, there was a probation revocation finding?
I think the definitive answer that I can give the court is that it cannot be revisited in a subsequent probation revocation proceeding where the same standard applies in the absence of an intervening conviction. And frankly, I don't know the answer if there is an intervening conviction, but I don't think it matters to the outcome of this case.
Well, it would seem, I mean, it may matter in terms of, I mean, what's strange about these cases, it's not the prosecution bringing the case, it's probation.
Yes. Oh, well,
except the prosecutor actually did the hearing, correct?
and it is, I mean, the Commonwealth is the party on the other side of the defendant at a probation surrender hearing. I cited Commonwealth versus Negron for that.
I always thought probation is the person who's the proponent of a probation violation. The Commonwealth may be there to assist.
But it's called Commonwealth versus, and it's...
Yes. Yeah. I agree with Justice Spotsford. I would point the court to footnote 12 in Crockett versus Commonwealth, which I didn't cite in my brief. I did cite Commonwealth versus Negron on this point, which Negron also describes the Commonwealth as the real party in interest. But in Crockett, footnote 12 says the Commonwealth is the party against whom a defendant litigates at a probation revocation hearing. I think that's...
I just want to make sure I understand what you were talking about a minute ago. Because in the context of probable cause hearings, bind-over hearings,
yes,
if a judge finds no probable cause, that isn't necessary. I take it that's not necessarily the end of the matter, that the Commonwealth could still seek an indictment if, as Justice Cordy was asking about, if they came up with some additional evidence, some new evidence, they could get, for instance, an indictment.
Yes.
And then a conviction.
Yes.
And then that conviction could be used to violate probation.
Even where a defendant had been found at the probation hearing not to, but again, this is the question that I think at this point I have to decline to answer because I just haven't considered it sufficiently to give a good answer because it's not presented here.
Fair enough, but let me move to another question. The Commonwealth says, okay, you know, what's good for the goose is good for the gander. If, in fact, the judge at this first probation revocation hearing had concluded, based on the evidence presented, that your client indeed, there was sufficient evidence to believe your client had violated probation by committing a new offense, are you bound by that at the second probation?
Yes. I'm going to sound like a broken record. I would first say that is a question that is not presented by this case, and I think there's no reason for the court to reach it, and in fact, I think it would be prudential not to reach it. The collateral estoppel cases are decided on they're very fact-bound, and the court in the past seems to have taken a very case-by-case, step-by-step
They're fact-bound and
approach
burden
to
of proof-bound as well, right?
Yes. And I think that it makes sense to do that because I think that's how the court avoids the potential pratfalls that might not be presented in a case where it is the defendant against whom estoppel is sought. I would say, though, that if the court is inclined to hold that this is a two-way street, that a defendant can be estopped just as the Commonwealth can be estopped, that I would disagree with the Commonwealth's position that the standards should apply equally, because I think there are concerns that affect criminal defendants that do not affect the Commonwealth, specifically the fact that a defendant has due process rights, that there are often very great resource differentials between the defendant and the Commonwealth, and the fact that the Commonwealth is always the moving party. They are always the party initiating the litigation. The defendant is never there by choice and may choose not to litigate, fully for a number of reasons that shouldn't apply to the Commonwealth. These are the things that I think are apparent without, just generally without even a fact-bound case to guide us. And so for those reasons, I would submit that I think specifically on the questions of a party's incentive to litigate and a party's incentive to appeal, that those are very different questions when we're thinking about a criminal defendant and the Commonwealth, who, in my view, always has an incentive to litigate if they have brought the charge.
Do we have to decide in this case whether a defendant, or whether the Commonwealth had a right to appeal where probation was violated on the administrative violation?
Yes, I suppose that you do. I had read Negron to answer that question conclusively, in that an adverse finding for the Commonwealth could be an adverse finding on any of the proposed or any of the charged violations. And I agree with the Commonwealth's view that they should be entitled to appeal when they when a judge finds that, you know, probationer has not committed the new offense, even if the judge also finds, as he did in this case, that the probationer has not kept up with his fee schedule. But I think the Commonwealth is right that if the court disagrees with that, we're in a different position. If they didn't have a right to appeal, then this is not a final judgment, and we can't assert estoppel.
Back to the question of which is really where the Commonwealth is arguing here, that you too should be bound. Mm-hmm. I mean, in a way, I understand they have to litigate, et cetera, but to some degree, what Suffolk may or may not put into it may be different from what Bristol does. Whereas the defendant is the same person in both. And so it's hard to see, at least theoretically for me, why there shouldn't be some sympathy to the Commonwealth's view here that it works both ways.
Yes, and again, I'm not taking a position either way here because it doesn't affect my client. All I'm suggesting is that, for example, on the question of the incentive to litigate, that if the Commonwealth is going to charge someone with violating their probation, they should be prepared in every case to put their best case forward. Whereas a criminal defendant, you know, who's facing a short suspended sentence might have every incentive to stipulate because, you know, that's what's going to get him out of jail that day. Yeah. And he also doesn't hold the cards. He doesn't know what's coming down the pike, whereas I think the Commonwealth does.
I should know the answer to this, but in a motion to suppress, if you have it in multiple courts or multiple counties because of a crime that was a spree, for instance, a crime spree, and a defendant files a motion to suppress that's denied in one court, is he collaterally estopped from litigating the issue in the other court, where the issue is the same?
I think that the answer to that would depend on whether it became a final judgment, meaning did he take an appeal, did he subsequently plead guilty? In Commonwealth versus Cabrera, I think it was the same county, but I don't think the result would be different. The defendant lost his motion to suppress, pled guilty, and then years later, the Commonwealth brought new charges based on the same evidence, and he was not permitted to re-litigate the issue because he had already had a full opportunity to litigate it at his first hearing. And that, I think that case illustrates to me why it seems fair to require that the Commonwealth put its best foot forward the first time around. If a defendant who doesn't even know he's going to be charged with these subsequent crimes years later, is collaterally estopped by pleading guilty after losing a motion to suppress, then it seems fair to me to say that if the Commonwealth chooses not to do its best job or not to appeal, that they should also be estopped.
Okay, thank you.
Thank you.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. Just on the subject of the Commonwealth putting its best foot forward, I just wanted to note that as an appellate attorney, I'm not fully up on this, but it's my understanding that probation revocations very frequently are not done with full evidentiary hearings, and essentially that there is a limit in resources in how these things are conducted, and it could be done various different ways with different amounts of resources, but I think the Commonwealth frequently does prioritize and make decisions about merits of cases. Certainly we do when taking appeals. It depends on the type of appeal. Some of them we have to pay for. But there's definitely a cost-benefit analysis within the Commonwealth about whether a particular case warrants being handled in a particular way. And obviously we have some ability to coordinate between counties, but we're not an 11-headed hydra. There's different things going on in different places.
So where does that lead us? Let's assume that the probation department has moved to revoke the probation because of a new offense, and simply calls the police officer to sort of recount what people said to him or her, and that might be adequate, but the judge says, I don't think that's enough, and so I'm not going to, I don't find that he has violated his probation in connection with this. Is that the kind of thing that would bind the Commonwealth in another county, moving and calling, for instance, the actual victims?
I would certainly like to argue no. I believe I think I felt I couldn't find a basis in this court's previous law for having that as a standard. However, it is a common law form of, it's not constitutional collateral estoppel. It is a common law and thus form of it, and thus presumably substantially within the discretion of this court. I know certainly there would be policy considerations strongly in preference for having us not be bound by the fact that another county chose to do a pro forma revocation.
Yeah, I mean, one certainly can imagine, maybe this goes to the incentive to appeal. One can certainly imagine that in one county the suspended sentence is really of not great significance, where in another county it might be of substantial significance, I guess.
In my brief, I think I pointed to the relative severity of the sentences as a metric, but it's certainly not the only way that it could be, I'd imagine, calculated in this case.
But you reserve the possibility that in that circumstance there may not be the same incentive and therefore may not be collateral estoppel.
Yes, Your Honor. I think that it would be important in crafting any rule about this to allow for the fact that there are cases where there's quite obvious differences in incentive, that and that if coordination between the counties fell through for whatever reason, that a county with a much more serious case should not be bound by the result in another county's relatively insignificant case, that would not be in the interests of the goals of collateral estoppel.
Does the judge's decision in this case preclude the Commonwealth from getting a criminal complaint based on the same evidence?
I believe there is a criminal complaint on the same evidence. It was filed without a change of plea. So
it was filed without a change of plea?
But it's that is independent of the probation revocation proceedings.
Was it filed because of a collateral estoppel argument?
Oh, no, it was filed, I believe, for reasons specific to the case.
Okay.
But that was handled independent. I think everyone is on the same page that the trial would not be affected by the results of the probation revocation, and vice versa.
Was it Fall River or New Bedford that the actual charge came out?
Off the top of my head,
It's one of the two that had the probation revocation.
yes, I'm not 100% sure. I feel like it was New Bedford. So that went forward independently and is in its current state independently of this issue.
So it sounds, I understand what, that you do make an argument, and I just have to say also, I thought, I wanted to commend you for taking the position that you took in this case. But one of the things you say is, good for the goose, good for the gander. But it also sounds like, just in what you were just saying with respect to the incentives of two, in a particular case may be very different, that in fact, maybe the most prudent course is to really think about this in a very narrow way, right? I mean, in other words, so not reach your issue, because once you start pronouncing things, you would say you run into trouble on either side.
I think that this court certainly has focused on narrow rulings in the past, and it would be its prerogative to do that now. I take the position that this is a relatively straightforward issue, that essentially we could save another trip to the SJC to discuss this. However, obviously that is up to you.
sorry, which trip could you save?
Excuse
If-
me?
if-
Which trip could you save?
Another trip to this court to resolve, if we had.
If it's used against the defendant.
Yes, that essentially, it's a matter of, I suppose, what this court considers would be the best way of addressing the issue.
Would embrace the goose and gander theme.
Yes, but I understand that there are other considerations that judges have.
And what is your position with regard to the subsequent conviction? Should we reach that issue, or should we leave that one alone, that Justice Cordy raises?
I think that that's certainly an interesting issue. I think that is another issue that probably is just going, when it comes up, it will come up at some point. I don't know how soon. But the last law on this issue was from the underlying issue in this case was from the 1990s. But that it seems like it is relatively straightforward on its face, and it seems to me that it does seem logical that if you go through a trial and you come out the other side with a conviction, that might reset the clock on this issue, which, again, it would only be if you could show beyond a reasonable doubt by a much higher standard of review. But just consistent with the idea of that the trial, that the trial and the probation revocation sort of operate independently of each other. But I would also understand if this court wanted to wait for that to arise specifically in a case. Yeah.
Well, I join Justice Botsford's view. It's in the highest tradition of prosecutors to recognize that they don't need to swing at every pitch. So we appreciate that.
Thank you, Your Honors. Commonwealth's rest on its brief.